Please rise. The justices of the Appellate Division Supreme Court First Department. Please all persons having business with the Appellate Division. Go here, to your sentence, and shall be heard. Please be seated.
Welcome to the Appellate Division First Department. We have over almost 7 hours of argument, time requested, so we ask that you only ask for the time that you actually need. We have reviewed your briefs and the records, and we are familiar with the cases. The first case on the calendar today is People v. Cannon for the appellant. I'm sorry. Okay, I'm going to make it 5, 2, and 5. Warshak versus City of New York for the appellant. Okay, for the respondent. Okay, 3 minutes. Cindy versus Marisol is submitted. Lomtevas versus City of New York for the petitioner. Appellant. Okay, I will give you 3 minutes. Buxton versus Zukov for the appellant. Respondent? Five, 2, and 3. People versus Angel Lopez for the appellant. Respondent? Okay, 4, 1, and 4. Cleary Thomas versus Thomas for the appellant. I'm sorry, is there, what do you mean 6, 2, and 3? 6 and 2. Okay. For the respondent? For the respondent, 5 minutes. Okay, 6, 2, and 5. Velasquez versus City of New York for the appellant? Respondent? 5, 2, and 5. WDF Inc. versus Vamco Sheet Metals for the appellant?
5 and 2 for the appellant.
For the respondent?
5 minutes, please.
5, 2, and 5. People versus Vasquez for the appellant? For the respondent? 3, 2, and 3. Chung versus William Schwitzer for the appellant?
The appellant requests 5 and 2.
For the respondent? Okay, is there no respondent here? Do you want to submit or do you still want to argue?
I'd like to argue and answer questions.
Okay, so I will give you 3 minutes. Giovanni versus Nicholas for the appellant? I know the respondent is not here. Okay, submitted. Dennis versus Board of Education for the appellant? For the respondent? 5, 2, and 5. Mancho versus Miller for the appellant? I'm sorry, what? Respondent?
Respondent Pasternak, 5 minutes, Your Honor.
Okay, 5, 2, 5, and 4. La Sala versus Russell for the appellant? For the respondent? Is the respondent not here? Do you want to submit? Okay, 3 minutes. Karen DeSecchi versus City of New York for the appellant. Respondent? 5, 2, and 5. People versus Paul Niles for the appellant. For the respondent? 4, 2, and 5. And Alexander versus New York City Transit Authority is submitted, and Greenway Muse is submitted. So our first case is People versus Canyon.
Good afternoon, Your Honors. Victoria Wu, Office of the Appellate Defender for Mr. Cannon. The evidence in this case did not establish beyond a reasonable doubt that Mr. Cannon had the intent to take the walkie-talkie permanently away. Indeed, the prosecution's own evidence, namely the video footage and the conductor's own testimony, showed that Mr. Cannon was mentally disturbed at the time of the incident. Among other things, Mr. Cannon stared at the conductor after he was told that the employee's stop was not his. He walked up and down the train
Counsel,
while...
let me ask you, the video was seen by the jury. Why isn't this a credibility determination for the jury to make, and why should we take that away from the jury?
In conducting weight of the evidence review, this court acts essentially as a second jury. And here, it's not a case where you're given two sharply contrasting narratives of what happened. The entire incident is captured on video, and Mr. Cannon explained his state of mind at the time. So the question here really is whether, in light of the evidence as a whole, the inference that Mr. Cannon had the intent to take the walkie-talkie permanently away is established beyond a reasonable doubt.
Doesn't the video show that he didn't actually give it back till he started fleeing the scene? Why isn't that enough for the jury, at least, to infer that there was an intent to take it for an extended period of time?
We're not raising a legal sufficiency claim. We're raising only a weight of the evidence claim. And our position is that if you look at the evidence as a whole, including the fact that he was mentally disturbed, experiencing severe delusions, and was afraid of what he believed was going to be a taser attack, that at the time that he took the walkie-talkie from the conductor, that his intention was not to take it away permanently from the conductor, but rather to take it temporarily as a means of self-defense.
Again, counsel, wasn't that a credibility issue for the jury to determine? I mean, he testified, so they have to determine whether or not they believe his explanation as to why it is that he took the radio.
Yes, the jury was required in the first instance to assess the quantum of the proof at trial, but this court, in conducting weight of the evidence review, again, in effect, serves as a second jury to make sure that the prosecution did meet its burden of establishing guilt beyond a reasonable doubt.
Why should we view it any differently than the jury did? I mean, you keep trying to make an enormous distinction between the two standards, but why does that change anything?
Because I think if you look at the evidence as a whole, the most plausible account of what happened really is Mr. Cannon's testimony that he was experiencing delusions, he was afraid of other people surrounding him, not just the conductor, but other passengers as well. And his intent at the time was not to take the walkie-talkie permanently away from the conductor. Again, the walkie-talkie is an item that is of negligible value. It's not like a wallet, a backpack.
Why don't you also address the excessive sentence claim about the sentences running concurrently versus consecutively?
Yes, Your Honor. So in the event that this court does not reverse the conviction, we would ask that the sentence be modified by running it concurrently to the other sentences that Mr. Cannon is serving. The fact that he took a walkie-talkie for just a handful of minutes does not warrant lengthening his state prison term by a magnitude of 1 to 3 years. Again, it's clear from the video itself that he was experiencing a psychotic episode. Mr. Cannon has a significant history of mental illness. He has been hospitalized multiple times. he has a history of suicide attempts. That mental health history combined with his history of substance abuse strongly mitigates his conduct in this case. And notably, prior to trial in this case, the people offered a plea deal, a misdemeanor plea, to 1 year in jail, which Mr. Cannon had already served by that point in time. So that plea offer made by the people below amply demonstrates that in their own assessment, no further period of incarceration was necessary for merely taking a walkie-talkie for about 5 minutes from the conductor. So in light of Mr. Cannon's history of mental illness, which obviously played a role in this incident, his history of substance abuse, and the fact that the people offered a plea deal to 1 year in jail, we would ask that this court modify the sentence by running it concurrently in the event that the conviction is not reversed as against the weight of the evidence.
Okay, thank you very much.
Good afternoon. May it please the court, Michael Yetter for the people. Defendant's guilt of fourth-degree grand larceny and resisting arrest was proven beyond a reasonable doubt. Defendant's argument essentially distills to a disagreement with the factual and credibility determinations made by the jury. But
The fact that he clearly was undergoing some mental disturbance at the time this incident occurred, how does that interact with his ability to have an intent to actually take the walkie-talkie as opposed to just acting out on his mental disturbance?
Well, I guess first, a technical point, there was no evidence at trial presented concerning his mental state other than his own testimony. So I think that still presented a credibility issue for the jury to determine. Yes, the video does show him walking up and down the train and engaging in odd behavior, and certainly Martin testified that he
I think you
thought it was
touched upon the key word here, odd behavior. It is apparent as he's walking up and down the train car that he's not well. He's mumbling things to himself. He's approaching people and saying things to them. He's approaching the conductor and saying things to the conductor, moving back away. So obviously, you can tell from watching the video that there's something wrong with this person. And he's not being violent. He's just acting, as you said, odd. So, as my colleague asked you, what about that fact? Doesn't that show that there's something wrong with him, and therefore he cannot have the mens rea to have committed this particular crime?
Well, I don't think so, Your Honor. I think the testimony and the video evidence that was credited by the jury showed that at the time he took the radio from Martin, or at the very least shortly thereafter, he realized that what he claimed was a taser was not in fact a taser, and that he realized that it was a radio, and he withheld it.
Didn't he give it back right away?
No, he held it for over 4 minutes before. He didn't give it back until right before he left and fled the scene of the subway station. And so we think that that evidence, considered holistically, and the jury made a reasonable determination that notwithstanding defendant's testimony, and there were many other reasons to discredit defendant's testimony beyond just the fact that when he said or claimed to be having these paranoid delusions, he quickly realized that they were not actually what was going on. But, of course, he was an interested witness. He was not forthcoming about the convictions that he had.
Let me ask you about the excessive sentence. Let's say it's not enough here to say that the verdict is against the weight of the evidence. It's clear that he was and does suffer from some mental health issues. Why shouldn't the court grant the excessive sentence request and have the sentences run concurrently rather than consecutively under the particular circumstances of this case?
Well, Your Honor, I think, as the court knows, he received the minimum sentence in this particular case. The conduct that led to the sentence in the Bronx County was obviously separate and distinct, so there's no issue with running it consecutively. I think this case itself presents an alarming situation where somebody got into an altercation with a train conductor at around 4 o'clock in the morning on a work day that caused alarm, and I think the video itself shows that it caused alarm to many of the passengers that were on that train and were within the frame of the video camera. It's just not, it's not, as my friend described, some sort of innocuous taking of a radio for 4 minutes before handing it back. I think it was a much more serious situation than that, even though it didn't ultimately lead to, physical injury or things like that.
But isn't he already going to be in jail for an extended period of time, whether or not these sentences run consecutively or concurrently?
The sentence in the Bronx is 8 years, Your Honor. I'm not sure whether those aggregate sentence there was the minimum. If not, perhaps defendant can pursue relief in that area, but I don't think the fact that the sentences were ordered to run consecutively here is excessive, particularly when the sentence that was imposed was the minimum. And I don't think the pretrial offer to a misdemeanor is particularly important. Here, the defendant was convicted at trial of a felony count, and of course, that offer was made 2 years before the trial in this case. In the intervening period, the defendant had other issues regarding his conduct in the Manhattan Detention Center. Yes, that conduct ultimately led to police to felony charges and I believe 1 day in jail on each charge. So it wasn't considered particularly serious, but a lot occurred between that initial misdemeanor plea.
Thank you very much.
Just briefly, Your Honors. On the weight point, I think respondent just argued that there's no evidence beyond Mr. Cannon's testimony about his mental state. That is categorically untrue. The video itself shows, as Justice Mendez was pointing out, that he was mentally disturbed at the time. The conductor himself testified that at one point, and as the video shows as well, Mr. Cannon took off his hoodie. He yelled out, "I don't have a bomb on me," because he believed that a female passenger was a member of ISIS. Clearly, his mind was detached from reality. And that corroborates and that establishes that he didn't have the mens rea to be convicted for larceny. So for that reason, the conviction should be reversed. Again, in the event that this court does not reverse the conviction, the sentence should be modified to run it concurrently to his substantial 8-year term. Respondent emphasizes that Mr. Cannon did have some incidents while he was awaiting trial, in this case, while in pretrial detention, but that is not what this sentence is for. This sentence here is for grabbing a walkie-talkie for a few minutes, and simply put, it should not lengthen the prison term by a magnitude of 1 to 3 years simply for taking a walkie-talkie while he was experiencing paranoid delusions. So again, for those reasons, we would ask that the conviction be reversed, and if not, the sentence should be modified to run it concurrently to the Bronx sentence.
Thank you very much.
Thank you.
Warshak versus City of New York.
Good afternoon, and may it please the court. My name is Amy Pimer on behalf of the respondents, the City of New York, and the Department of Transportation. We ask that this court uphold the underlying decision granting summary judgment to the respondents. The respondents established their prima facie case to summary judgment. Since the center median's installation in 1953, the city—
Since we're all familiar with the case and the other side isn't here, let me ask, does anybody on the bench have any questions for counsel?
Nope.
then we rest on our brief. Thank you very much.
Great, thank you very much. The next case is Lomtevas versus City of New York.
Good afternoon. May it please the court. Carla Denali on behalf of Respondent Port Authority of New York and New Jersey. Your Honors, we'd ask that the court affirm the trial court's dismissal of the complaint as to the Port Authority of New York and New Jersey in this matter. It is clear, I think, from the allegations in the plaintiff appellant's
So, counsel, let me ask you this.
Sure.
If we agree with you that the special relationship part has not been adequately pled, what about negligence, and what about the two cases that have stated that one can plead a claim for negligence in not putting up sufficient barriers on the bridge?
Sure. So, and I believe, Your Honors, you're referring to Feldman, which is this court's determination, and Perlov, which is the Second Department's. It's our position that both of those cases are distinguishable from the current case in the sense that this court, for example, in Feldman, made a point of very specifically indicating that the claims there were very specific to.
So let me be more specific then on how, I'm not sure how you can distinguish Feldman. In that case, the court said, it's known to the Port Authority that the George Washington Bridge is a suicide magnet. Based on that knowledge, there's an issue of fact as to whether or not it should have installed handrails, and it was the lack of the handrails that made the person able to jump. How are those facts, which are really the heart of that decision, any different from the facts in this decision that the Port Authority still knows it's a suicide magnet, still has not changed the handrails, and it was the lack of the handrails that caused the decedent to be able to jump? So why, on that level, is the case distinguishable?
Because in this case, Your Honor, the plaintiff pled facts that brought this case closer to the governmental function.
So you can make an argument that there is no governmental function claim. There's no claim based on any actions of what a Port Authority officer did or did not do. But how does that take away that other basic claim, which clearly was upheld by the First Department in Feldman, putting aside those other allegations?
I think in this case, it's not clear that one can do that. There are very few instances in the plaintiff's complaint where she actually speaks to the issue of the fence, and when she does, it's always in conjunction with a challenge to the policing.
We have all the facts before us, so why, even if it was poor pleading, it's whether it states, even for dismissal, it's whether it states, not whether, they pled it right. So why on a summary judgment motion would not look at basically undisputed facts in determining the motion?
I would submit, Your Honor, that in this case, even if one were to stay, and we don't agree that this particular complaint lies on that end of the continuum that's a proprietary function as opposed to the governmental function, but even if one were to view this complaint in that fashion, the plaintiff would still have had to establish a special duty by the Port Authority to the decedent. And in this case, that hasn't been established.
No, that's not.
Counsel, I just want to go back because I'm actually looking at the complaint, particularly paragraph 64. It sets forth that the George Washington Bridge, it's a dangerous instrumentality. It's a haven for suicidal individuals. The Port Authority was aware regarding the dangerousness of the bridge, and with respect to the attempts on prior occasions by other persons, and what could have been done to prevent it. It's set forth here, paragraph 64 and paragraph 65, as well as the fact that you own it.
I agree, Your Honor. Those allegations are in the complaint, but also in the complaint are allegations that there are no active patrols, that and that's at paragraph 7 of the complaint. Later on, that at paragraph 30, at page 33 of the appendix, at paragraph 44, for example, of the complaint, it's alleged that the length of the walkways.
So why wouldn't we? I know she has another question, but why wouldn't we just dismiss it to the extent it alleges any special relationship claim, but uphold the claim to the extent it alleges that there was a lack of handrails and that was the cause?
I think in this instance you can't do that, Your Honor, because there is an allegation in this complaint that when the Port Authority police patrolling the bridge actually heard chatter on the NYPD radio.
Okay, I get that there's more. Do you have any more questions?
No.
Any more questions? Okay, thank you very much.
Thank you.
Buxton versus Zukov.
Good afternoon, Your Honor. I am Anthony Green. I'm here on behalf of third-party defendant Appellant Rafelson and Levine Law Firm, PC. This case involves claims for contribution and indemnification under the theory that my client committed malpractice by failing to seek leave to file a late notice of claim in order to cure the third-party defendant Seth Zukoff's failure to file a timely notice of claim in the first place. However, the longstanding precedent in legal malpractice cases is that an attorney is not liable for inactions or events that occur after the representation is terminated.
What about the fact, though, that there was a wait of 2 months before the law firm even discovered that the notice of claim had not been filed, and the allegation, which I'm sure you dispute, which is that they were told to go back to the original law firm, the client was told to go back to the original law firm, that was nothing that your firm could do?
Well, we did terminate the lawsuit or the representation while the plaintiff had 5 months to retain new counsel. And in fact, that allegation is not founded in the documents that, or the letter, the termination letter, which tells the plaintiff exactly what he needs to do, the deadlines he needs to meet, and gave him ample time to find new counsel or proceed however he wished in order to try to file a timely lawsuit and a motion for leave to file a late notice of claim.
Counsel, the firm had the file in July. So what did the firm do between July and September? Because it just seems to me, if you have the file, it would have been so obvious, you know, if somebody opened it and looked at it, that, oh, there's no notice of claim, we need to take action.
Well, I can't say why it took 2 months, but again, it was the time period, the deadlines in question. They all expired when we were not counsel of record. And this exact situation was looked at by the third department in Sheretov v. Kapocha, and the third department found in favor of our position. And in that case, the attorney only had left 1 month for the former client to retain new counsel and file a timely lawsuit and seek to file a late notice of claim. Here, they had 5 months, and we told him exactly what the problem was. He acknowledged that. He said at his deposition that my client did nothing wrong. And I think with the 2 months, the question of whether they had the opportunity to file a timely lawsuit and to seek to file a late notice of claim is not really the issue. The question is whether they had a duty to remain on the case after discovering that error and alerting the client to that and telling them that we weren't willing to take the risk on a contingent representation. You'll need to find new representation.
Let me ask you another question, because I know, plaintiff claims that the firm advised him to retain for a second time the attorney who failed to file the notice of claim. That's obvious. There's no dispute, and certainly the firm disputes that. So if there are two conflicting versions about who said what, doesn't that raise credibility issues which warrants the denial of summary judgment?
No. Retaining his former counsel was certainly one option, but
really? Is that really an option? I mean, someone who obviously fails to file a notice of claim, I mean, that's like lawyering 101. You would go back and tell that person, go back to that attorney who obviously dropped the ball?
Well, it would give that attorney the opportunity to cure his negligence, and most attorneys, I would think, would take that opportunity and avoid a lawsuit, which perhaps he could have done had he accepted the representation.
Counsel, going back a little bit, on July 16th, 2013, a letter is sent out to Zukoff saying, stop work on the case. We are retaining Rafelson and Levine as our new attorneys. The question is, when did exactly Rafelson and Levine receive the file in this case?
Well, that's not in the record, and I can't tell you for certain when that happened, but it did happen at some point after that.
After July 16th, 2013.
Right, right, and we're talking about a less than 2-month span.
And then in September, they review the file and immediately send out a letter saying, we're not going to represent you, get another lawyer.
Correct, Your Honor.
Okay, thank you very much.
Thank you very much.
Good afternoon. May it please the court. My name is Hillary Simon for the respondent, Seth D. Zukoff.
Counsel, I have a question for you.
Yes.
When did Mr. Zukoff's office send the file over to the firm of Raphaelson and Levine?
It was on right after he received the letter on July 16th of 2013.
So what's the date right after? Was it
It was that day that they
the
had
very
a phone,
same day?
Yeah, they had a phone call with the partner. Seth Zukoff had a phone call with the partner at Raphaelson and Levine, and he sent over what documents he had.
Is there anything in the record that would indicate the exact date that this file went out?
There is not anything in the record that indicates that. It's based on the testimony of my client as well as the testimony, well, they haven't been deposed, but.
We don't have any documentation to say that it went out on the 17th, the 18th, or maybe even in August. We have no idea.
We don't have documentation, but it hasn't been disputed that they received everything that they needed in order to move forward in filing a notice of
It's
claim.
obvious, but the question is, when did they receive it? When did they review it so that they could then reject the case in a timely basis?
Right, I understand, Your Honor. It's not in dispute, though, that they received the file right after July 13th of 2013, and that they then had 6 months, 2 weeks, and 5 days to timely file a lawsuit against the relevant entities based on the 1 year and 90 days.
What was the malpractice, though? If they got the file, so the notice of claim wasn't filed, they clearly sent a letter to the client saying, there's a statute of limitations issue, you have to do something, we're not going to do it, and there was still 5 months to do it. Why are they a contributing cause of this case ultimately being dismissed?
Right, Your Honor. The issue is that they had sufficient time and opportunity to protect the plaintiff's rights, and
Why did they
failed
have to?
do so.
Why, you're basically arguing that they were forced to continue representation in this case when they did not want to continue representation. What obligation was there on their part to say, first we'll fix the problem the other law firm made, file a late request for a late notice of claim, and then we'll get rid of the file? Why are they obligated to do that?
Well, because they had a 2-month time period where they did nothing on the case, at least 2 months.
Why were they required to do anything?
Because
other than to let the client know the statute of limitations has run, there's an issue, and you need to do something. We're not going to do it for you. What else are they required to do?
I mean, I believe that there's law in the First Department, which is dispositive on the case, including SOMA, which is 44 AD 376, and Golden 286 AD 2D 281, which says that the element of proximate cause can't be established in a malpractice claim where successor opportunity had the sufficient opportunity to protect the client's rights, and they didn't do so.
Okay, thank you very much. I'm sorry, does anyone have any other questions?
Counsel, let me ask you two questions, two quick ones. You're not disputing that it was your client who blew the 90-day statute, correct?
Yes, Your Honor.
So that's in dispute. And you're also not disputing at the time that the second law firm decided not to represent the client, the second statute, the 1 year and 90, hadn't been blown.
It
So
hadn't.
there was still plenty of time for someone to do it, to make that motion, correct?
Correct, Your Honor.
Okay,
I think the
thank you.
distinction, okay, thank you.
Thank you, Your Honors. I just want to address again the issue of whether they told them to go back to the original attorney or not. And in the record at 349 to 350, in the termination letter, which the plaintiff acknowledged receiving, They don't say to go to Zukov necessarily. They say, we urge you in the strongest terms possible to consult another attorney immediately in order to be certain not to jeopardize your rights nor allow any legal deadlines to expire. So that's the documented evidence. And if the court has no further questions from me, I yield my time.
Thank you very much.
Thank you.
People versus Lopez.
Good afternoon, and may it please the court. Alma Gonzalez for Mr. Lopez. A downward modification to SORA Level 2 is appropriate in this case. It's now been 30 years since Mr. Lopez committed the sex offense in this case. It is actually his only sex offense on his record. He was 16 at the time that he...
Counsel, that seems to be your primary argument, that there's been no further sex offenses that he's convicted of in the last 30 years. But aren't we also entitled to consider, and the SORA court entitled to consider, his conduct while he was in prison, which certainly things clearly happened there, and also his arrests and convictions for non-sex-related offenses in the 30 years as part of the analysis?
Yes, Your Honor, and we're not suggesting that the court is not permitted to consider that, but 2 points on that. Regarding the prison conduct, there is one sexually related disciplinary ticket on his record. That occurred in 1993, 2 years after the offense in this case. So since then, there's...
But isn't there also evidence that he made on multiple occasions, he made reports of gonorrhea in an effort to expose himself to a female nurse there?
So that's why he ended up receiving the ticket ultimately. And
that was on multiple occasions, not just one occasion. Is that correct?
Correct. In the time span between the conviction in 1991 and his imprisonment and the ticket in 1993.
Did he also attempt to ejaculate on a nurse?
Correct, which, you know, we're not saying that that's not serious conduct and that it's not relevant. It is. However, that was also the reason for denying downward departure back in 2005, I believe it was, at the redetermination hearing. And downward departure, I believe, was also denied at the 1997 initial SORA hearing. So previous courts have already taken that into account, and the question here is whether sufficient circumstances...
What about his extensive convictions for both felonies and misdemeanors in the intervening 30 years, many of which involve violence? Isn't that something that the court is also entitled to consider in denying a downward modification?
Yes, Your Honor. I think to strike the appropriate balance here, we're not requesting a level 1 in this case. We're only requesting a level 2, and I think that a level 2 sufficiently takes into account the fact that Mr. Lopez does not have a perfect record. He hasn't had a perfect record since that time. The felony conviction also did occur, I believe, more than a decade ago, back in the late 1990s.
Oh, counsel, he was convicted in 2009, 2012, 2016 of 3 violent criminal acts, right?
Well, no, Your Honor, those were misdemeanors.
3 violent offenses.
They did involve inherently,
choking,
yes.
right? All 3 of them. One in 2016. So that clearly wasn't taken into account by the first SORA court, right? The first hearing.
Correct, Your Honor, and we
the court
admit
this
that.
time had the opportunity to take care to view those 3 crimes: 2006, 2009, 2012, 2016, all choking crimes, right?
Well, yes.
All violent crimes.
The 2012 and the 2016 were yes, and the 2009, yes, Your Honor.
So those weren't taken into account the first time he sought a reduction.
Correct, yes, that's true, and that's why we feel that a level 2 would be more appropriate than a level 1 reduction in this case. That more appropriately strikes the balance between, you know, the 30 years without any type of sexual recidivism on his record, in addition to the efforts that Mr. Lopez has made since then, he's not the same person he was when he was 16.
Thank you. You have time for rebuttal.
Thank you, Your Honor.
May it please the court, Christopher Peterson for the office of Darcel D. Clark. A level 3 adjudication reflects defendant's risk to the community. He has not shown that his risk has diminished in the time since his conviction. If anything, he has shown that he's capable of great violence. If your honors have no further questions, the people request an affirmance.
I do have a question. Counsel, is there any evidence that he completed the substance abuse treatment or sex offender treatment?
I don't see in the record any certificates of completion, just counsel's affirmance on the record.
Thank you.
Thank you very much.
A few points as to Your Honor's last question. There is evidence of that. Again, counsel did affirm that Mr. Lopez completed the mustard seed program, which was a 2-year sex offender treatment program. That was actually a mandatory condition of his 2012 probationary sentence. Respondent has not contested that Mr. Lopez completed probation, and therefore that is sufficient evidence of his completion of sex offender treatment. And additionally, there are other factors that the court may consider in this case, in addition to his record, which are the fact that he has been the primary caretaker for his mother, who suffers from diabetes and severe joint pain. Mr. Lopez has also availed himself of resources in the community, and he also now is a father himself to 2 sons. We submit that sufficient conditions here have changed since 1991 that merit a reduction, at least to a level 2, which sufficiently accounts for his conduct since.
Thank you very much.
Thank you, Your Honor.
Cleary Thomas versus Thomas.
Good afternoon, Justices. May it please the court. I'm Mia Poppy on behalf of Appellant Nicole Cleary Thomas, and we are asking this court to reverse all branches of the trial court's decisions and to remand it back to the trial court for further proceedings to determine the best interest analysis for the children. This case arises out of the nexus that many cases in New York have risen. The pandemic occurred, and these parties were parties who resided in 2 different Manhattan apartments. They have 9-year-old twin children.
We're familiar with the case. Why don't you pick which argument you want to focus on, since you made many different arguments in your paper.
Okay, so as an initial matter, it's not disputed in the record that there was a substantial change in circumstance. In the record, it sets forth clearly, father moved to Long Island, Riverhead, mother with the children moved after him.
Are you, just to clarify, are you making an argument now about why the radius clause should be no longer be enforceable? Is that, the substantial change you're trying? Because there's a lot of moving parts in this, so you need to tie it into which argument you're addressing.
So first of all, the lower court held that there was no substantial change in circumstance.
Such that would warrant a change in the radius clause. Is that what you're referring to?
Such that would warrant a change in the radius and warrant the other relief that was granted.
And you're arguing that the pandemic is a change, substantial change in
I
circumstances?
am arguing that on the face, that defendant couldn't argue that there wasn't a change because defendant himself moved from Manhattan to Long Island, and then thereafter, the plaintiff moved. And
so
then,
are you saying that we should disregard, there's a radius clause here, it's undisputed, it's in the agreement. The radius clause says 5 miles from the party's residence, marital residence, which is clearly in Manhattan. Are you saying that because the parties both moved out for a period during the pandemic, that radius clause should no longer be an enforceable document, an enforceable agreement? Is that the argument that you're making?
the argument is that the 5-mile radius clause can't be applicable because neither party lives in the apartments that they lived in.
But at the time, the agreement clearly states that it's 5 miles from the party's residence, and it even makes a reference that outside of Manhattan is beyond that radius. So there's no question, at the time the agreement was entered into, they were talking about Manhattan, and they were talking about the marital residence.
And then they both moved.
Exactly. So my question for you is your argument then that the pandemic is the change in circumstances and them temporarily moving out because of the pandemic that would justify now no longer enforcing the radius clause?
Absolutely, and neither party is inside the 5-mile radius clause. Father moved to a new apartment in Soho that's more than 5 miles away from the 2 apartments that they were in at the time of the agreement. Both parties moved, and not only did both parties move, Father listed his apartment inside the 5-mile radius for sale, so he disposed of that apartment in its entirety. They both moved to Long Island. Mother moved to a house that the then 8-year-old children had lived in for 7 years.
Counsel, are the children right now going to school in Manhattan?
The children have always gone to school in Manhattan.
Right, and the father is even though he doesn't live within the 5-mile radius, that's the middle point, and the father wants the agreement to remain, correct?
Yes, but the 5-mile radius clause is abrogated because he lives outside of the 5-mile radius.
Why
Counsel,
does
that also
abrogate
says-
it? I'm sorry. Why does that abrogate the clause? It's a reference point to where the parties will connect, right? And the children.
Absolutely, and you cannot look at that without looking at the impact on the children. Where Mother was residing is a house that the children had resided in for 7 years of their now 9-year lives. None of Father's parenting time was impacted. The children's school wasn't impacted. And moreover, the children were in a home that they had been accustomed to. So yes, that warrants the 5-mile radius clause that neither of them live in to be abrogated.
But it also says, and or outside of Manhattan. Clearly, Soho is in Manhattan. It's not just within 5 miles of the current residence, but it also says outside of Manhattan. So how do you deal with that? Outside Manhattan, you either need the party's consent, a parent's consent, or court order. You don't have either. And it's in Manhattan.
You did have consent, and he withdrew his consent.
Was it written? Was it written? It says it has to be in writing.
Exactly. So, Your Honor, yes, the 5-mile radius says that they both need written consent to move. Both of them move without any written consent. I'm just saying that the party should have parity in treatment. Just because Father moved back before Mother does not mean that Mother has to pack her bags. Mother received an email, it's in the record, on October 18th of 2020 saying, I'm moving to Manhattan with my girlfriend. And the next day he was gone. And
the children are now back in school in person in Manhattan also, right?
The children are back in school in Manhattan, and the mother still wants to reside in Long Island because she believes it does serve the best interest of the children. In Long Island, the children can run, play, they have deep connections.
Thank you. You'll have rebuttal time.
Thank you.
Good afternoon. May it please the court. Michael Calogero,
Counsel,
Cohen Clare et al.
That move to Long Island, was it a permanent move or was it a temporary move because of the pandemic?
It was a temporary move because of the pandemic, Your Honor. The record, it makes that point very clear. This family did what many other families did in March of 2020, is they temporarily retreated out of New York to their second homes, not their primary residences, their second homes in Long Island. Towards the end of the summer, around August or September, Mr. Thomas notified his ex-wife, I need to go back to Manhattan with some degree of permanence. I need to be back in the office. That is when this all broke loose of the fact that Miss Cleary Thomas tried to use the pandemic to get to relocate permanently to Long Island. There is nothing in the record showing that this was ever done with any degree of permanence. In fact, the emails and text messages that are in the record show that Mr. Thomas constantly said, this is not a permanent move. This is temporary. I need to be back in the city come this fall.
How do you reconcile counsel's statement that your client put his apartment up for sale, his apartment in Manhattan up for sale, after he went to Long Island?
Because he is now residing with his girlfriend in Soho, and that is, by the way, within the 5-mile radius. That is in the record as well, too. There's a Google Maps printout showing that it is within 5 miles of 300 East 56th Street, which was the party's then marital residence at the time they entered into the custody agreement, to which the radius clause was forever tethered. And also, if you look at the radius clause, it says that they need to stay within 5 miles of that residence and or within Manhattan, as your honors correctly noted. And it notes they can't relocate their primary residence. It does not say anything about second homes. What these parties did, as I said before, they went to Long Island temporarily to their second homes. No one changed their primary residence. Most of all, my client did not, and he is within the 5-mile radius now. He's back living in Manhattan.
Sir, pursuant to the agreement, as the prevailing party, the actual agreement provides for attorney's fees, correct?
That is correct.
So there's really no basis to set aside the $10,000 award.
Not only is there no basis to set aside a $10,000 award, as I point out in my brief, there were 5 independent bases for the award. And additionally, Your Honor, there is a basis based on the breach clause in that agreement to award fees on appeal, which I respectfully request.
Did you make a cross appeal, though?
I'm sorry, Your Honor?
Did you make a cross appeal?
We did not cross appeal.
How can we give you any affirmative relief on this appeal if you didn't cross appeal?
Because
What would be the authority for us to give you affirmative relief?
Because there was nothing wrong that the lower court did. It was correct, everything they ordered previously.
That's not my question. My question is, if you didn't make a cross appeal, what would be our authority as an appellate court to give you further relief, as opposed to you going down below and saying, you know, we did this appeal and we want to collect attorney's fees?
It's on the basis.
We don't have that application before us.
It's on the basis, Your Honor, that this is an entirely baseless appeal. There is no reason for it. This should never be brought here, and my clients had to incur tens of thousands of dollars for me to stand here today, for me to put together the brief, for me to go over the record and the brief put in by appellant, and I would respectfully request that his reasonable attorney's fees be awarded on appeal.
Counsel, did your client try to accommodate the plaintiff in terms of finding a middle ground where they could either drop off the kids or maybe reside?
Absolutely, Your Honor. And as Justice Katz specifically noted on the record in the lower court, he said my client bent over backwards to try and reach an accommodation here. The party's children for the 2020-2021 school year were being schooled entirely remotely. And my client said in sum and substance, let's work something out. If you want to stay out there while they're being remotely schooled, let's go to a week-on, week-off schedule. We can so the kids aren't going back and forth 2-3 hours in a car one way, 2 or 3 times per week. That accommodation was rejected by appellant, and also appellant declared that my client needs to go out there needed to go out to Riverhead to pick up the children at the start of his parenting time, including very early in the morning sometimes. So that accommodation was rejected, and that was why this entire proceeding was brought and why the initial application was brought on behalf of my client.
Is it in the best interest of the children to continue to reside in Long Island?
No, in fact, they do not continue to reside in Long Island. They're both in New York right now because they're being schooled on the Upper East Side. It makes no sense and is inimical to the children's best interest to commute roughly an hour to an hour and a half one way to school each day. I see the light is going off. I thank the court for your time.
Any further questions from the bench? No. Okay, thank you very much.
Thank you very much.
I would submit to this court that it is inappropriate to award counsel fees based on a breach that they both committed. The radius clause specifically said that neither could relocate outside of the 5-mile radius. Dad did, she followed. Also, the record is very clear, the record at 89, that Dad sent Mom an email on October 19th saying, I'm moving back to Manhattan, and he left the very next day on October 20th and then filed this instant motion on November 1st. Moreover, Mom asked for counsel fees for a breach. because mom complains in her papers that dad is constantly getting the children COVID tested, and the agreement expressly says any non-emergency care, the parties have joint decision-making and they must be conferred jointly.
I'm sorry, counsel, is COVID testing treatment?
It's
more of a
medical attention
diagnostic.
because medical
Why
providers.
why would you need consent to give a non-invasive test that has nothing to do with treatment per se?
Well, because the agreement calls for it. The agreement says any non-emergency medical treatment. So it's what they signed up for. It's not what I'm saying.
No, but counsel, a COVID test isn't treatment. That's the point, correct?
It says any medical education.
Treatment.
Yes.
But that means a COVID test is not medical treatment, is it?
But there's no reason why one parent should not tell the other parent. And in regards to middle ground, mother in her paper said, I want to move to Port Washington because the commute to Port Washington is shorter into the city than the commute from dad's Soho up to the Upper East Side. So mother at all times was trying to come to a middle ground. Mother said, I want to move to Port Washington. Thank you, Your Honor.
Thank you very much. Velasquez versus City of New York.
What'd you drop?
What did you drop?
May it please the court, my name is John Moore and I represent the City of New York. Because plaintiff cannot show either that he suffered a serious injury or that any injury he did suffer was caused by the car accident he alleged, Supreme Court erred in failing to grant the city's motion for summary judgment. This court should reverse and honor the no-fault law's purpose of keeping minor personal injury cases out of court.
Let me ask you, how the burden doesn't shift on causation unless you made out a prima facie case of causation. Didn't you yourself, the city, present some conflicting evidence with respect to causation?
No, I don't think that's right, Your Honor. So there's no, the plaintiff refers to the report from Dr. Ferreter, which diagnosed sprains that had all been resolved within 6 months of the accident in question. So, and there's no allegation that sprains constitute serious injuries within the meaning of the no-fault law. And in fact, they definitely don't, particularly ones that are healed within 6 months.
But isn't it true that defendant's own orthopedic expert, he did opine that the injuries were resolved, but then he also opined that the injuries were causally related to the accident?
So again, it's worth looking at what injuries he said were causally connected. So the injuries that plaintiff is now alleging are the serious injuries at issue are disc herniations, radiculopathy, symptoms relating to that. That's different from sprains. Dr. Ferreter said that the sprains that had been resolved were caused by the accident, but that's a different injury than the one plaintiff is saying is the serious injury. Again, a sprain is not a serious injury within the meaning of the no-fault law. And so we made our prima facie case on that. There's no evidence in any of the record presented by the city that the accident.
Well, what's the sprains or strains referring to? What part of the body?
From the back, neck, and wrist.
Why isn't that a matter of degree? He's calling it strains and sprains, but he's referring to the same injury that the plaintiff is calling herniations. It's the same body part, therefore undercutting the causation argument.
No, Your Honor, sprains and disc herniations are different injuries. It's not a
same location on the body, though.
That's true, but the fact that it's the same location doesn't indicate a serious injury caused by the accident. And then that's what we have to be focused on within the meaning of the no-fault law. It's whether there is a serious injury caused by the accident.
There's two things we have to focus on. One is whether there's a serious injury, which we can discuss, but the other thing is causation. And they're two separate things that we have to consider. So aren't you mixing up the issue of whether it's a serious injury with the issue of whether causation, you've made the prima facie on causation?
No, Your Honor, because a sprain is an injury, it's a torn or stretched ligament. The disc herniations that we're talking about are the basically cartilage pads that separate the different vertebrae in the back and neck and spine. So an injury that's diagnosed as to ligaments is not an injury related to those
Okay, well,
cartilage
let's
pads.
go to serious injury. Let's say you made your prima facie on lack of a serious injury. Why wasn't that rebutted or an issue of fact raised based on the treating physician's findings of significant limitations in range of motion in the cervical and lumbar spine within 2 months of the accident, and MRI scans from shortly after the accident showing disc herniations and bulges?
So I think our primary argument and our best argument on the question of serious injury is the unexplained and unexcused nearly two-year gap in plaintiff's treatment, and that
Well,
alone is
haven't we
sufficient to
held
defeat his claim.
Hasn't the First Department held before that a sufficient explanation for that gap in treatment is that decided to continue treating at home and doing the exercises at home once the physical therapy terminated?
So I think Your Honor is referring to the Wadford decision, which plaintiff cites. And the difference between Wadford in this case is in Wadford, the indication from the decision is that physical therapy had reached the end of its usefulness, that it had gotten as good as it was going to get and everything else was just on its own.
Wasn't it also based on the fact that no-fault benefits ended at that point and a decision was made to do at-home treatment once the no-fault benefits ended?
Yes, but so on page 596 of the record, Your Honor, the difference in this case is that plaintiff's physical therapy provider said in this case that he doesn't require physical therapy. That's what it says on page 596 of the record.
Because he's reached maximum medical improvement, so there's nothing more we can do for him, is that it?
That's not how I read his statement. So that's different from, for instance, from the Brown case, which is cited in the Pommel's decision. It's different from Wadford. It's not saying physical therapy wouldn't do any more good. It's saying he doesn't need physical therapy. He doesn't require physical therapy.
Okay, thank you. You have rebuttal time.
Counsel, how old was your client at the time of the accident?
State her name for the record first.
Oh, just good afternoon. Marielle Crippen, Burns and Harris for plaintiff respondent. Did you say how old he was?
Yes.
He was 30 years old at the time of the accident, no prior injuries, and there's no degeneration in his own medical records. The only claim of degeneration comes from the defendant's doctor, who actually states that one of the herniations that she does find is of an indeterminate age. So I'm not sure that would even meet their burden of establishing that it is in fact degenerative, and that's in the cervical spine. Additionally, to the extent that—
Counsel, let's just start with your adversary's argument that you didn't adequately explain the gap in treatment. What do you have to say about that?
Okay, as far as the gap in treatment, it was not 2 years, quite as he says, but regardless, plaintiff testified that his no-fault benefits were cut off. There is the record from the physical therapist that at that time, which is what it states, at this time, further physical therapy will not do him much benefit, something along those lines, and I recommend he does a home exercise program. He continued to do a home exercise program. This is also addressed by Dr. Wiener in his report, where he talks about how the plaintiff did do a home exercise program. He did go back to treatment after the gap and continued to treat, and he did ultimately have a fusion surgery at the C5-6 level where the herniation was found.
Do you agree that the defendant made out its prima facie case as to a lack of causation of physical injury and then you rebutted it? Or do you think that the defendant didn't make out their as to causation, no, as opposed to the physical injury, about serious physical injury, do you agree that the defendant made out its prima facie with respect to causation and then you rebutted it? Or do you think that the defendant didn't make out their prima facie as to causation?
I do not believe they made out their prima facie as to causation, partially also because of the fact that their doctors, including not just the orthopedist, but the neurologist, Dr. Tabador, finds significant range of motion limitations in the cervical and the lumbar spine. He does not attribute that to any other cause other than this accident. And his report actually states the plaintiff would benefit from continued stretches and core exercises to deal with his discomfort. He also talks about how those activities restricted him from interacting with his children and from performing his job duties. Essentially, on both causation, even if they were to find that they met their burden on causation, it is adequately rebutted by Dr. Wiener's report, who had treated this particular plaintiff from 2016, shortly after the accident, all the way up until 2019 when he did issue his report. I would also argue that if we could switch to the issue of the injury and the seriousness of the injury, they don't meet their burden on that either for similar reasons, significant range of motion limitations found by their own experts, Dr. Tabador, 33% loss in right lateral flexion in the neck in his cervical spine, which correlates very much with his testimony as to his right-sided pain, his right-sided wrist pain, and the radiculopathy that's also found in his records and submitted and commented on by Dr. Wiener, who issued his narrative report.
Was there any surgery recommended for this patient?
Yes, Dr. Galina's records are in the record, and in there it's discussed that he would try an epidural injection, which he did have in 2019, and that if he didn't respond well, he's a candidate for surgery. And it was Dr. Galina who ultimately did perform the surgery, although the surgical report is not on the record because it was after the motion was decided.
Counsel, I just want to go back. With respect to the defendant's medical experts, did they at all address the findings in plaintiff's medical records?
No, they don't discuss, and in fact, I believe Dr. Tabador says there were no diagnostic studies available for him to review. So he does not comment on the EMG study, for example, or the MRIs in that regard. They don't address the fact that he was asymptomatic before the accident and only had symptoms after, that he has no prior medical history, except for Dr. Ferreter does say that there's no pre-existing conditions that would affect his impression, which was cervical strain resolved, lumbar strain resolved. But he does causally relate those complaints and restrictions to the subject accident.
Thank you very much.
Thank you.
I'd like to start just by clarifying a couple of points from the medical record. Plaintiff argues that Dr. Tabador found significant range of motion restrictions. In fact, on page 369, he says he found minimal limitations. If those finding minimal limitations, which can be addressed by home exercise and stretching activities, has never been found to be a serious injury within the meaning of the no-fault law. Plaintiff referred to Dr. Luster in saying that the injuries were of indeterminate age. What that meant was, in context of the report, was that there was no evidence of an acute injury, an acute trauma that could have caused those injuries. In fact, Dr. Lustern said that the evidence indicated that they were degenerative. This would explain why an additional herniated disc was found 3 years after the accident that did not appear on the MRIs taken more contemporaneously with the accident. If all the herniations were caused by the accident, there's no reason there would be a 3-year delay before that herniation became present. A degenerative condition, though, would explain that. Plaintiff has also never addressed the biomechanical engineer's report issued by Dr. Sadig, which said that the accident could not have caused, the accident as plaintiff described it, could not have caused the injuries that he described. Plaintiff's only response to that is to say it's their position that there's other things that the engineer should have taken into account. But that position is not supported by any evidence within or outside the record. Given the record that is before the court, plaintiff has not been able to establish either that his injury was serious or that it was caused by the accident that he alleges. Unless the court has any further questions, I'm happy to rest on my briefs.
Thank you very much.
Thank you.
WDF Inc. versus Vemco.
May it please the court, Terrence O'Connor for the defendant, appellant, Vamco Sheet Metals, Inc. This is a construction payment and performance dispute, contract dispute between WDF, the HVAC prime contractor, which I'll call the general contractor for ease of reference, and its sheet metal subcontractor that was hired to furnish and install the ductwork on a high-rise
So
construction.
why shouldn't we find, based on the evidence that's been presented, that there is ample evidence that there was a breach of the subcontract by VAMCO in terms of the way it handled the work?
The issues on this project were complex. The project was delayed from the outset, and it was accelerated from the outset. As set forth in the opposition papers.
What about the failures which occurred after that 6-month delay period? Once the project resumed again, it was going forward, there's ample allegations that there were not laborers supplied as required by the contract.
They are allegations that were vigorously opposed during the project and in the opposing affidavit submitted in opposition to summary judgment.
Evidence that there were sufficient workers at the site?
Yes. And that's a judgment call being made by a general contractor. These types of disputes are commonplace when you have accelerated construction projects. 14% of the performance period was taken away. The order of construction was completely changed from what was agreed to, so that you had stacking of trades.
Let me ask you something. Putting that aside, what about the undisputed evidence that VAMCO cheated on the pressure test? Why wouldn't that be a breach of VAMCO's performance obligations under the statute?
That is one item of breach that was conceded at the summary judgment level. And the law is clear on that, that if a party wants to take the position that a particular breach gives grounds for termination of the contract, you have to assert it then, and you cannot continue to demand performance after whatever that breach item was, accept continued performance, and then after the fact, months later, come back and say, well, I should have terminated the contract months ago, so I'm terminating it now. The Pavkov case discusses that. It's an election of remedies issue, and they never even pretended to terminate the contract based on that one issue, which is of almost no economic consequence on this job, in the face of a $5 million counterclaim. $1.8 million of base contract not paid, and more than $2 million of additional extra work not paid for. GC got paid for it, done by VAMCO. They kept the money. They did the same thing on a delay impact claim, resulting in multi-millions not being paid.
Can you put your mask back up, please?
Excuse me?
Your mask.
Oh. Which resulted in
certain places are not requiring masks, but we still are, so.
The reversible error as a matter of law is the lower court held that you can sever out the payment issues on a performance payment dispute. The Seglin case and the 4 other non-payment breach cases that I cited all say as a matter of law, you cannot do that. The 2 issues are intertwined, payment and performance issues. And it was held in the Seglin case, Second Department. This is a 100-year-old case law going back, and it's all consistent on this. Even where breach is proven on the performance end, you cannot grant summary judgment because the payment end also has to be decided. It's all one contract. This court severed out the payment issues and said, because we can't decide that, even though it's millions of dollars, we'll go to trial on that because there are triable issues of fact on the payment end, but we're going to award liability and damages on the performance end, all disputed. 15 issues of fact were identified. It takes me 3 pages in my appeal brief to describe the complicated issues of fact on a case like this that were addressed in the Veterino opposing affidavit, citing to project correspondence, schedules, contracts, requisitions, etc. Admissible evidence contesting every single one of the 15 issues, all except for the one relatively trivial air duct test, and as a matter of law, they cannot say that constitutes a breach sufficient to terminate the contract because they chose not to.
You have a rebuttal. Thank you.
May it please the court, Andrew Richards for the respondent WDF.
Counsel, what's your response to that argument, that under established case law, you cannot separate out the breach from the amount owed, and that was improper as a matter of law for the court below to do that?
It makes no sense. That's my response. It's easy. The contract between the parties allows us to withhold payment, and here in this case, what they're talking about, what the trial court found was that there was liability, breach of contract by VAMCO, okay? So now, what the trial court, Justice Borak, did was he found the completion costs over and above the subcontract balance due and owing. When the trial court is saying I'm reserving the counterclaims for trial because those counterclaims concern delay claims, acceleration claims that they reference in their brief. But in their brief, they don't show with any admissible evidence or anything beyond conclusory allegations that they're entitled to that money. That's what the lower court has to figure out now, and that's what we're going to try. I hope that answers your question.
What about the allegations that there's disputed issues of fact about whether there actually has been a breach of the performance obligations under the subcontract?
Oh, have mercy. Mr. Vetterino wasn't even on the project. The lower court took into account every argument they made. It's not WDF who, in its own infinite wisdom, decided that they weren't performing. Turner Construction, the construction manager for the dormitory authority, was beating up WDF because of VAMCO for over a year and a half. And what VAMCO did to WDF is it put WDF in jeopardy of having its contract with Turner terminated because WDF is responsible for VAMCO's performance. So we're talking about, and I wrote a note here, my adversary says there was no evidence of, you asked if there was any evidence of ample workers. There's none in the record. Nothing. The record is replete with documents, meeting minutes, everything, showing that they weren't performing for over a year and a half. And quite frankly, what's most disturbing is, the email, June 5th, 2010, where WDF directs to adequately staff, and VAMCO's representative says, you don't tell me what to do, end of story. That's not how it works. That's not what the contract says. Turner gives directives. They want to change the sequence, and I know this court hears a lot of delay claims, because I've been before you many times, especially Your Honor, and you have to abide by the terms of the contract. If you want to submit a delay claim later, you submit a delay claim. But if the GC, that is Turner, directs you to accelerate, directs you to go out of sequence, guess what? You have to do it. That's the contract.
Okay.
I could go on.
Any questions from the bench? Okay.
Anything? You sure?
We're
I could
sure.
really go. Okay.
You could stay here all day long, right?
No, I actually took the train today. I'm not driving home anymore.
Okay.
We could be here all week arguing the performance issues
Let's not.
on a complex, commercial, accelerated, compressed construction project. The case law that mandates reversal of this decision are the 4 non-payment breach cases, which specifically hold, even if you can prove performance breaches by a subcontractor, you cannot award summary judgment when there are outstanding countervailing payment claims by the subcontractor against the general contractor. It's one contract.
And what's the case that says that?
That's the Seglin case, saying you can't, and that's Second Department, 1933. And if you go to page 23 through 26 of our main appeal brief, we discuss these 4 non-payment breach cases at length. 3 of them are trial cases, which is appropriate. There has to be a trial to prove complex breach cases on an accelerated construction project. These things can't be decided by conclusory assertions. You need to give me more manpower. GCs say that on just about every construction project. You can endlessly add manpower to any job. If they demand more manpower, that doesn't mean there's been a breach by the subcontractor to perform his work. especially considering in the Vettorino affidavit, he talks about the fruitlessness of adding more manpower when, because they took away 14% of his performance period, everyone was on top of each other on this accelerated project. That's not a breach by the subcontractor. That's a breach by the general contractor who's ordering endless amounts of manpower when they're all on top of each other. These are the issues you get on these construction schedule disputes. They're complicated cases. The trials on these things go on for a month.
Okay.
It can't be decided on summary judgment.
Thank you very much. No, that's not right. But Jim. People versus German Vasquez.
May I wipe down the?
You may.
Thank you.
I assume that's why they were put there.
I think so. Good afternoon again. May it please the court, Alma Gonzalez for Mr. Vasquez. Although we're requesting a reduction to the minimum sentence in this case, even a 6-month reduction would have a significant impact not only for Mr. Vasquez, but his family. We don't discount the severity of the injury that occurred in this case, and Mr. Vasquez was supremely remorseful for that, even apologizing to the victim in this case. However, there are other factors that additionally have occurred since then, including the pandemic, that have really compounded the weight of the sentence in this case. As your honors know from the briefs, Mr. Vasquez is the father of 3 sons. 2 of them are still currently minors and in the care of his elderly mother, who is a cancer survivor and is now in remission.
Counsel, just a question, because we know that he's the primary caregiver for the 2 sons, and you're saying that that should play a factor in us reducing the sentence. My question is, when he was convicted and incarcerated in Florida, I believe it was 2012, he was the primary caregiver then, correct, for the 2 sons?
Correct. He was the primary caregiver then, and then he served his time in Florida and specifically moved to New York to be closer to his parents so that they can help him take care. Well, actually, if I could retract that, Your Honor, I believe that when he was in Florida at the time, the mother was still present in the case. It was after Mr. Vasquez moved from Florida to New York because the mother was no longer present. She actually ended up leaving to California. So I believe that at that time, they were in the care of their mother and not Mr. Vasquez. But since then, obviously, the pandemic has compounded the weight of the sentence on his mother particularly. She's caring both for the 2 minor children, one of whom has a learning disability and mental health issues as diagnosed and as documented in the sentence memo. She's also caring for herself, for her own cancer remission. She's also caring for Mr. Vasquez's father, who is also ill. I know that this
Counsel,
is
can we talk about the complainant here who received a slash to her face, in essence requiring 150 stitches inside and outside, and her facial nerves were severed, and she can't smile, and she has an difficulty eating because of the injury, and the fact that she was not really in agreement with the sentence that was imposed on Mr. Vasquez here.
That's correct, Your Honor, and you know, like we conceded in the beginning, the injury is severe. It undoubtedly is. Mr. Vasquez is extremely remorseful, but we would add that since then, what the sentencing court was not able to take into account is really the impact that the pandemic has had. I mean, on all of our lives, but also on this family. And you know, 6 months is all that it would take. Thank you.
Very much.
Good afternoon. May it please the court, Catherine Reed for respondent, the Office of the Bronx County District Attorney's Office. Your Honors, this sentence is not excessive. Defendant, as Your Honors know, slashed the 31-year-old unarmed female victim in this case, causing a severe laceration extending from her hairline to her mouth, requiring over 150 stitches and leaving her permanently deformed. The victim is unable to smile, experiences difficulty eating, and has undergone numerous plastic surgeries. Had defendant been indicted and convicted of the top count after trial, he would have faced a maximum sentence of 25 years in prison.
Counsel, the complainant has children also, correct?
That is correct, Your Honor.
So this crime has affected her children equally, correct?
That is correct. She has 3 young children, Your Honor, who now fear for their mother's safety and have been severely impacted by this assault as well. Again, Your Honors, the lower court here had significant reservations about this plea deal at the outset, and over the victim's objection, the defendant was still permitted to plead guilty to a reduced count of second-degree assault and received just 3 years imprisonment with 3 years post-release supervision. If Your Honors have no questions, I rest on my brief and ask this court to affirm.
Thank you very much.
I would just add to that, Your Honor, that 6 months really is not a big reduction, and there's no additional benefit to society from keeping Mr. Vasquez in 6 additional months when we could immediately alleviate the pressure that is on this family, on this mother, on the children. And for those reasons, Your Honor, we feel that at least a 6-month reduction would be appropriate in this case.
Thank you very much.
Thank you.
Chung versus William Schwitzer.
Good afternoon, Your Honor. May it please the court. I'm here on behalf of, my name is Hal Lieberman. I'm here on behalf of Mr. Schweitzer, who is the appellant apparently under the consolidated cases and the captions, but there are cross appeals, and apparently my opponent decided not to appear here. Despite the finding by the trial court that Mr. Chung's claim for millions of dollars in so-called origination fees fails because it was based on an indefinite oral agreement that violates the statute of frauds. And despite a further finding that the only writing that exists, which they now claim takes it out of the statute of frauds, is a certain email which does not constitute a writing that it constitutes a meeting of the minds with respect to...
Why isn't that writing sufficient to take, the email sufficient to take the agreement out of the statute of frauds?
Because it doesn't, as the trial court found, it does not constitute a meeting of the minds. It's vague, it's ambiguous, and it cannot be...
But doesn't it clearly say that there will be a success fee on clients that Chung brings in? So
well,
why
that's
isn't that an agreement that there'll be compensation for Chung for clients that he brings in?
The term brings in is the ambiguous term, Your Honor. The brings in term means, to Chung, at least his understanding as he testified in his deposition, was that he'd get a success fee on every...
What on the face of it makes it, we only look to extrinsic evidence if it's ambiguous. Brought in, why on its face wouldn't that encompass both types of bringing in? Bringing in from his personal network and bringing in from advertising?
Because that was not according to the trial court, and I think the trial court was correct, that did not constitute a meeting of the minds, or was it an unambiguous term? The brings in could be from a personal family connection, or it could be from the ad campaign. Obviously, Mr. Chung interpreted...
Why couldn't it be both?
It could be both. It could be both or either. It's possible, but it was an ambiguous term, and it's a difference of millions of dollars, as well as the fact that, by the way, it also was ambiguous as to the fee structure. There was 3 different fee structures. He said in the email 25 to 30%, and then in his complaint, he asked for a third. And in various affidavits in which he filed charging liens, which were all rejected, I might add, he also asked for a third.
Thank you. Are there any questions from the bench on this matter?
So it's our respectful request that you reverse on the summary judgment issue on the breach of contract. Appreciate it. Thank you.
Giovanni versus Nicholas? Oh, what? No, it's not submitted anymore. Judge Kennedy, Justice Kennedy is recused in this matter. I'll step out. So I was informed that you arrived late, and because of that, really you should not get any oral argument because you're required to give you 2 minutes.
Okay, thank you.
To
I
say whatever you
apologize.
wish to.
Since I only have 2 minutes, I'm going to obviously have to be quick. If you have any questions, please ask.
Are there any questions from anyone on the bench? No. Okay.
This case is quite extraordinary, actually. It absolutely requires reversal. There was no criminal intent and all legitimate purpose. The petitioner did not prove the elements of any crime, which they would have to do, even if it's only preponderance of the evidence. In this context, I was dealing with an emergency. My mother had threatened suicide, and actually, as a result of petitioner, who's a 15-year...
Sorry, can you pull your mask up?
Yes. As a result of a younger man involving himself in her life, and he was holding her medications and didn't give her medications, those being opioid medications, causing her to go into withdrawal. The petitioner testified in court that he was not afraid of me, which itself nullifies the elements of any of these purported family offenses. He stated on the record he was laughing at me. In the brief, the citations to the appendix where he made those statements is in the brief. The petition was defective. It had no specific times, dates, or specificity to anything. The only specific reference was 2009, which was 4 years before my mother had purportedly had married him, so there was no family court jurisdiction over anything in 2009. The court also erroneously stated that I had admitted to making some kind of a death threat, which I did not make or admit to. December 28th, my mother threatened suicide. I called EMS. Police came to the apartment. I had no interaction with the petitioner. The police actually said they were going to arrest him, but somehow this has been construed as something against me. January 5th, I came back to check on my mother. I asked a police officer there.
Thank you. Your time's up. We are familiar with the case, and we have read the briefs.
Okay, thank you.
Thank you. Okay, Dennis versus Board of Education. Is your opposing counsel here?
He was, yes.
I guess he's not anymore. Do you still want to argue if he's not here? Well, I'll give you the
Yes.
time. If he doesn't come in, we'll cut it.
All right. Good afternoon. Oriana Vigliotti for Appellant Audrey Dennis. In this case, the New York City Department of Education wrongly accused Ms. Dennis of misconduct. They tried to terminate her employment. During the course of that hearing, it came out that she hadn't committed the misconduct, and the DOE correctly...
Let me just ask you, so is the relief that you're seeking here to get the no rating changed to a satisfactory rating?
That's right.
And also, you're still trying to get back pay?
Correct. That's exactly right. And the reason that the no rating the court can and should order the DOE to annul the no rating, which isn't provided for in the contract, and revert back or reinstate the S rating.
It's because there's no such thing as no rating.
Correct. It just doesn't exist under the contract. And this woman, the DOE, she was the director of the Office of Salary, Genevieve.
Okay, so let me ask you about the back pay issue.
Sure.
To get back pay, you'd have to show that she otherwise would have got back pay if she had been satisfactory. And how can you possibly make that shown with all the uncertainties involved in who does and does not get called in to do work in the summer?
Correct. Well, based on Ms. Dennis's, she was a 30-year employee. Based on her seniority and her retention rights, which is what she lost by virtue of the wrongly issued U rating, she would have gotten the position.
How have you made that showing that she was high enough in the list, there was enough openings, there were X amount of openings in that, but for this no rating, she would have gotten the work that summer?
Well, in the petition, it stated that she'd worked this summer position for many, many years.
Right, but isn't it different every summer, a different amount of openings every summer? Because you were eligible one summer, why does that mean you're eligible another summer?
I mean, that is true, although in reality, in this case, with her 30 years and her,
Wouldn't that be speculation? Aren't you basically acknowledging that speculation, whether she would get it?
I will acknowledge that she didn't apply because she knew it would be futile to apply. Had she applied for the position, she knew she wouldn't have gotten it, and the DOE knows that she wouldn't have gotten it because of the U rating. Had she applied with an S rating, she would have received the position just as she had for numerous summers in the past. And she didn't do so because it was futile for her to apply.
Are there any other questions from the bench? Okay, since the other side, or is the other side here? Then I'll let you have all your time since, if he wasn't here, I would have cut off your time.
Okay.
Go ahead.
So it is also important, though, and it means something going forward, that this contractually non-existent no rating be annulled, and the satisfactory rating that was issued to Ms. Dennis by her direct supervisor throughout the course of this litigation, once the DOE understood, yes, okay, we see that this underlying disciplinary action has been withdrawn, the letter to file has been withdrawn, there is no U rating, the principal issued to Ms. Dennis a satisfactory rating. And then, after she filed her petition, the DOE by this woman, Genevieve Aloya, who is, like I said, the director of salary services, she is not an administrator, she doesn't know Ms. Dennis, she went in the system and she issued this contractually non-existent no rating, and that is arbitrary. And that is why, in this case, it's important for that no rating, which doesn't exist, to be annulled, and the satisfactory rating that was in fact provided to Ms. Dennis by her direct supervisor should be reinstated.
And the Board of Ed wouldn't consent to that relief?
They wouldn't do it. We talked to them and they would, but they did do it. So we filed a petition. Here, this case involves a petition and an amended petition. We filed the initial petition because she still had the U rating. And then when the initial petition was pending, yes, the Ms. Dennis's union rep went and spoke to the supervisor and to the superintendent, and the superintendent instructed the principal, issue the satisfactory rating, and she did. And that happened in, sometime after the petition was filed. And in January, Ms. Dennis worked per session because she had this S rating. Then all of a sudden in February, while this petition is still pending, Ms. Aloya changes the S rating to a no rating. And then we filed the amended petition saying, okay, the U is gone, but now we have this contractually non-existent no rating, and that's still, Ms. Dennis is still being harmed by this because she still doesn't have a satisfactory rating, and that affects her, and it affects her ability to work this per session, and that's important for a school secretary. These are not highly paid employees, and working these additional hours is really important to her. And until this contractually non-existent no rating is annulled and the satisfactory rating reinstated, she's not going to be able to work this per session job.
Counsel, how do you respond to the respondent's argument that your petition is moot because you did not grieve as per the collective bargaining agreement?
Right. Two issues there. One, I would argue that the petition is not moot because Ms. Dennis is still suffering harm. There's still a live controversy. She still has this contractually non-existent no rating and not the S rating. And with respect to the idea that she didn't grieve this no rating, there is no procedure to do that under the collective bargaining agreement. The collective bargaining agreement allows for appeals of ratings, and it is very specific, and it is with respect to also the bylaws of the Board of Education, and you can only appeal for a secretary an unsatisfactory or a doubtful rating. You cannot appeal
Let you
this.
finish that up on rebuttal.
May it please the court, Daniel Matza-Brown for the respondents. I want to start first. My colleague just ended with about exhausting a challenge
Why
to a
don't we
no
first
rating.
start with where is the authority under the rules and regulations for a no rating? I mean, I've personally never heard of a no rating. Where does that come from, a no rating?
Well, Your Honor, a no rating is what is left any time that this court annuls a rating by DOE. It's a commonplace practice for there to be no rating, especially when there's an agreement or settlement.
You're saying if a court annuls it, but this wasn't a court, this was DOE. Instead of changing the unsatisfactory to a satisfactory, they just put in a no rating. What's the authority for the DOE to agree to expunge an unsatisfactory and not replace it with a satisfactory?
Your Honor, there's nothing in the CBA that requires a rating, especially for any particular period, right? So right now we're talking about a 22-day summer term.
But where's the policy and procedure that allows the DOE to impose a no rating when it expunges an unsatisfactory?
Your Honor, it's policy and practice. It happens.
You're saying that, but where, is there somewhere in the policy and practice?
There's nothing in this record, Your Honor. I mean, for instance, one example is
There's nothing you've put forth to the court. So then let me ask you the related question, because we ended with the administrative procedures and filing a grievance. If there's no procedure under the CBA for challenging a no rating designation, how could the petitioner have brought a grievance when there is no procedure for challenging a no rating designation?
Your Honor, her argument about the CBA having no procedure is flatly contradicted by its text. She alleges, Ms. Dennis, by the text of the CBA. The CBA sets forth a broad grievance procedure for any alleged violations of the CBA. So that's the broad provision. My colleague is correct that there's a narrower provision that deals with U ratings, right? But that's a separate special. Doesn't
that imply that if there's a way to challenge U ratings and there's no way to challenge no ratings, that there's no way to challenge no ratings?
No, Your Honor. If you bear with me, here's an analogy that I think is similar to this situation. Let's say that I have a bakery and I have all my baked goods are $1, except for cupcakes with green sprinkles, and those are 50 cents. If you see a cupcake with red sprinkles, you say, well, you don't say there's no price for that. You say, oh, I looked at the general price. The CBA has a broad general provision.
Let's say you were making the argument that she couldn't grieve it. Wouldn't that be your argument? There's a specific provision that says you can challenge unsatisfactory, but there's no equivalent provision for no rating. By a fortiori, you can't challenge that.
No, Your Honor. No, there's a broad provision to challenge any violation of the CBA, and
why do you need a specific provision for unsatisfactory?
That's a special additional protection that was negotiated for U ratings, Your Honor. But there's a broad provision in the CBA to grieve any alleged violation, and it should be the administrative process in the first place that says yes. This is the way you grieve it. This is you say, a violation of the CBA, and you go through the grievance process. But just because a special avenue doesn't apply, that doesn't mean that the broad avenue doesn't apply either. You use the broad general grievance.
What type of ratings do you have? You have a satisfactory rating, and you have an unsatisfactory rating, correct?
There are others that are incorporated under Article 20 that's in other evidence that's not within the record, Your Honor. Again, this is a motion to dismiss, so we did not answer. You know, if the court believes that there's factual development necessary, then I guess you remand for an answer to be put in. But I can represent to you here that under Article 20, there are other sorts of ratings besides UNS.
So, counsel, why wasn't it arbitrary and capricious for you to change her satisfactory rating to no rating? Where did that come from? What was the justification of changing? She got a satisfactory rating, it's in her file, then someone went in without any further proceedings, without any further notice to her, and changed it to no rating.
And Your Honor, that should be addressed administratively in the first instance, which would develop the record, right?
The question is, counsel, let me just finish my question.
Yes.
She alleges that's arbitrary and capricious. What do you say to that? Why is it not?
It's not, Your Honor, because she admitted in the stipulation to misconduct during a 22-day term, right? And that's enough of a rational basis to say for that short 22 days, the question is whether DOE must give her an S rating, and the answer is it need not.
It did. It did. It's not, there's no question. It gave her, her superintendent gave her. The question is, why was it changed?
No,
that's the problem. she got her satisfactory rating, and then someone somewhere went into the computer and changed it. Why is that not arbitrary and capricious?
Your Honor.
Why is the change from satisfactory to no rating not arbitrary and capricious?
Your Honor, the S rating was not official, and it was, as alleged, given by the same
It's in
principal.
the record. I see it. It's from her superintendent. It's on a piece of paper. It's in her file. How could it not be official?
Your Honor, it's, I believe, signed by the same principal who was alleged to have been engaged in the misconduct that she admitted to. But again, this should be in the administrative process in the.
Is it not in
and
the
that would
record?
develop the
Does
record.
she not, in her record, have a piece of paper in her official record that says big S on it?
Your Honor, DOE should not be bound by.
Answer that question, and then I will definitely hear everything you have to say.
Yeah, yes, Your Honor, absolutely yes.
There's a record.
Yes, and may I finish?
Sure.
Thank you so much. And I understand that my time is up.
Your time is up.
Yes,
So finish quickly.
DOE should not be bound in perpetuity anytime one of its agents writes S on a piece of paper, and DOE believed that it was appropriate to give no rating here. This should be aggrieved and dealt with in the administrative process in the first instance, which would give us a record upon which to
Thank you.
assess
Thank
the
you very
rationality of
much.
that decision. Thank you
Do you
very
have any
much.
more questions? Okay.
Article 16 of the collective bargaining agreement specifically provides that secretaries who receive doubtful or unsatisfactory ratings may appeal under section 5.3.4 of the bylaws of the board. That is the procedure in the collective bargaining agreement. The collective bargaining agreement defines grievances. It has a provision. A grievance is defined as any violation of the collective bargaining agreement, what you'd normally think. The term grievance shall not apply to any manner as to which a method of review is prescribed by law or by any bylaw of the Board of Education. So, Your Honors, this is correct that there was no method, there was no procedure available to appeal or to grieve this no rating. And I would like to also state that, and the DOE tries to make this argument in their briefs, Ms. Dennis didn't admit to improper.
Let me ask something, just procedurally. Normally, if their motion to dismiss is denied, they are given the right to answer. Why is that not the appropriate thing to do in this case?
I mean,
Give them
because
the right to answer the petition.
we have a full record here. I mean, we have the record.
Legally, is the court allowed to bypass that step after there's been a motion to dismiss, which is denied? Is it the next procedural step to allow an answer?
That is correct, and I assume that in this case, I feel confident that if that was what to happen here, that Ms. Dennis would prevail, but I don't think we need to get to that step. The lower court could be reversed, and this court could.
But if we reverse, I guess I'm asking, isn't our only authority to reverse to deny the motion to dismiss?
No, I think the court can reverse the lower court and order the DOE to remove this contractually non-existent no rating, replace it with an S, and to make Ms. Dennis whole.
Okay, thank you very much.
Thank you.
Moncho versus Miller.
Sorry, petitioner, this side?
You are arguing first, right? And that's where you sit and that's where you go.
Very well. Good afternoon, Your Honor. Thomas Goodman, or appellants. This matter is a matter of attorney malpractice arising out of a bankruptcy. Essentially, what we have here is an attorney named
I'm sorry, so who are you representing in this case?
I represent Lee Moncho, individual plaintiff, and his corporation, 261 East 78th Street Realty Corp. As I was stating, what we have here is a case of attorney malpractice where an attorney named Pasternak sought and successfully threw his flock to the wolves. What the court erred in finding that appellants lacked standing was in in fact,
Sorry, if you
contravention
could
to...
just stay a little closer to the microphone.
Certainly, Your Honor.
Thanks.
The court's holding that my client's lack standing was in contravention to applicable bankruptcy law across the unified circuits.
So your argument is that we should be following the bankruptcy law rather than our prior precedent because the bankruptcy law is federal law and it's federal cases.
Not only because it's federal law, but because it's unified federal law and it is the current state of law. What is currently precedent in this department is law which reaches back to well over 30 years before the bankruptcy code was wholly amended in 2005. Since then, as I state, all of the circuits have come into uniformity that post-petition causes of action become the asset of the debtor.
Okay, assuming you do have standing for purposes of our argument, do you want to address the viability of the malpractice claims and why they should survive a motion to dismiss?
Indeed, Your Honor. The court below unfortunately applied the wrong standard. While it articulated the standard of dismissal motion, it actually in fact applied the standard of a motion to motion for summary judgment. That is to say that the holding in, I see my time is up.
No, you have 2 more
Okay,
minutes.
sorry. That is to say that the holdings in Brooks and Phillips and Smith, as cited by my opponents, came out as a result of summary judgments. Had this court granted essentially any kind of reasonable inference or favorable inference to the fact that the malpracticing lawyer accepted a $25,000 commission to look the other way in introducing his clients to con men who he then worked hand in hand with over the course of 2 years.
Are you also saying that part of the breach, though, was that they didn't do due diligence into who he was recommending as a
Absolutely.
plan funder?
It was,
they actually had a history of problems which were never
yes,
recovered.
which are well documented. Unfortunately, part of that inference is by being paid a sum of money that by a third party, not his client, that he told his client that these were reasonable and viable plan funders when in fact they absolutely were not. I would also note for the record that the two quote-unquote plan funders, essentially con men, while they have made appearances in the IAS part, have not entered their opposition herein. Therefore, those portions of the brief should be deemed as unopposed. Thank you.
Okay, thank you very much. You'll have rebuttal time.
May it please the court, Rob Bergson for respondent Jonathan Pasternak. With respect to standing, counsel misstates the standard. There is no uniformity.
Sorry, there is what?
There is no uniformity. In this
Among
case,
the federal courts?
no, there's not, Your Honor.
What is the lack of uniformity that you're referring to?
I'm sorry, I can't hear you.
What is the lack of uniformity of the federal courts on this issue?
Well, there
Federal
are
cases going the other way.
There are cases going both ways. That there are cases that say it's got to be pre-petition, and other cases that say it's both
Can you cite
pre
us
and post.
one case as of 2017 that goes the other way?
Well, we do in our brief, Your Honor.
Yeah, can you, which one? I mean, the ones you cited were the ones that I looked at were our state cases, which are quite a bit older. Which one have you stated since then, in the
Well,
last
I mean,
4 or 5 years?
Clearly in the first department has said is both pre and post.
Right,
I'm
but putting
talking
aside
about-
the first department,
Right.
we're talking about the federal uniformity.
Well, there are cases that go both ways, and it hasn't been decided by the Supreme Court. And in this case, we have a.
Again, can you cite to me from your brief one case that goes the other way in the last 5 or 6 or 8 years?
I don't have that case, Your Honor.
Thanks.
I don't have the case, Your Honor. But in this case, we have a plan that specifically provided that any claim of the debtor belonged to lofts, not to the debtor. But in any event, even if the court were to find that there was standing here, when we focus on the legal malpractice claims, the court applied the correct standard under 3211. The fact that the court cited to several cases that happened to involve summary judgment, it did so with respect to general propositions, such as legal malpractice cases can't be predicated on speculative claims.
Counsel, isn't the law, though, that it's almost never appropriate to decide a causation issue on a motion to dismiss as opposed to a motion for summary judgment?
Well, no, that's not the case, Your Honor. There are plenty of cases that do that. And in this case, you have to look at it in the context. You have a debtor that came in with a $17 million debt. As a result of the plan of reorganization, it was reduced to $10 million. There's absolutely no evidence in the record that there was anybody other than Miller and Spry who could come in to fund this plan.
Didn't he clearly testify that there was a third party who was going to come in and he was going to go with that third party? And it was only Pasternak's recommendation of Spry that convinced him not to go with the other funder? Because Pasternak specifically recommended Spry?
Well,
And that Spry got a kickback for doing that?
Pasternak did not specifically recommend Miller and Spry. The only evidence in the record is a bald allegation.
But this is a motion to dismiss.
Right, it's pre-answer.
Yes, Your Honor, it is
So
a
he
motion.
has alleged that Pasternak recommended Spry, that he did that and that he had someone else available that he would have used, but for the recommendation, that was incorrect advice because there was a litigation history involving Spry, that he got a kickback for recommending Spry, and that he would not have incurred the damages he did, which was Spry's inability to fund the reorganization plan if he had if Pasternak had not breached his duty to him. Why isn't that enough to allege a malpractice claim?
It's not enough to allege, Your Honor, because just simply saying that he's talking about specifically Lightstone Group. There was no commitment from Lightstone Group. There's absolutely no evidence in the record that there was anybody other than Miller and Spry.
His allegation is that he stopped those negotiations because Pasternak recommended Spry.
Well, that's not the allegation that they made in the case, Your Honor. But
Not the allegation?
no, it's not. In any event, the plan was funded. That's undisputed.
But there was a subsequent default, it's alleged, because Spry never had the ability to carry forth on the alleged promises to fully fund the reorganization. Instead, took out loans that could not be paid back in default. Those are the allegations. Whether or not they can be proven, I have no idea, but we're on a motion to dismiss now.
I understand that, Your Honor, but we have documentary evidence in the record that the plan of reorganization was, in fact, funded.
Through loans.
Excuse me?
Through loans.
Yes, the original
Which were
lender was
defaulted
taken
on.
out. A new lender came in, and then 16 months after the plan of reorganization was fully funded, the allegations in the complaint are that Miller and Spry committed fraud.
Thank you. We're familiar with the facts.
Okay.
I mean, with the allegations.
I understand.
Thank you.
Good afternoon. May it please the court? My name is Joan Martino, and I represent the Del Bello firm in this matter. As far as the standing issue is concerned, the federal court cases can be distinguished because we have Bankruptcy Code 241A, A17, which says that property which comes into the debtor's possession after the bankruptcy petition is filed is the property of the bankrupt estate. And then there are cases such as Chart that actually look at the claim or the cause of action to see if it relates back to the bankrupt before the bankruptcy. So like in cases of car accidents, you're suing for a broken leg. No, that's not part of your
But
bankrupt
are you trying to
estate.
argue that there's an argument to be made that these claims arose before?
No, I'm
before the
saying this is not
bankruptcy?
a bright line test. This is not a bright line test. There's not a difference between the law in the First Department and the federal cases.
Why?
Because the federal cases look at the type of claim.
But don't the federal cases say uniformly that if the case arises after the commencement of the bankruptcy, then it's not the property of the estate?
No, they look at what the claim is. It's not a
They don't
black
look at
and
the
white
timing?
test.
So what kind of claim do you think, post-petition claim, post-petition, what kind of claim do you think the estate retains post-petition, and what case are you talking about?
Okay, I'm talking about Charts as the case. I think that in this case, 261 Realty owned a building. They defaulted on a mortgage. They filed a bankruptcy petition. The mortgage was paid off by the plan funders. The property was transferred to 261 Lofts.
But plaintiffs, let's start with this.
Yes.
So you are arguing that plaintiffs' claims arose pre-petition?
No, I'm not arguing
So
that.
what
It's
post-petition
tied
claim
to
do
his
you think?
pre-petition property.
Okay, I can't hear you if you try
I'm
and
so
talk
sorry.
over me. I just want to know, what post-petition claim do you think the estate owns rather than the plaintiff?
The claim that 261 Lofts lost the property.
That's not, the plaintiff's claim is for malpractice and fraud, right?
Right, but
that's damages. That's the damages they allege, but that's not the claim.
Okay, but part of any malpractice claim is damages.
Right, but the type of the damages doesn't determine whether the claim is pre or post petition. And if it's post petition, I think we can agree that it belongs to the plaintiff, not the estate.
Well, there's a line of cases that if it's post-petitioned and you don't amend your bankruptcy petition to include the claim, you can't bring the claim. It belongs to the estate. Property that a debtor acquires.
Pre-petition.
No,
if there's a
post-petition.
pre-petition claim,
yes.
If the claim arises pre-petition and you don't and you discover it post-petition, and then you don't amend, I agree with you, but I don't think there are any cases that say that if the claim arises post-petition, not that you discovered it post-petition, but that it arose post-petition, that it belongs to the estate. I don't see any cases that say that, particularly not in the bankruptcy court and particularly not in any of the circuits.
Okay, but in the First
So if
Department.
you think there is, then you should tell me.
Okay, in the First Department, that is the current, that's current law. Okay. Yeah.
Your time's basically up there now, so thank
Pardon
you.
me?
Your time's up. Okay. You have 2 minutes. You have 2 minutes.
Thank you, Your Honor. First and foremost, the notion that the bankruptcy petition should have been amended is an impossibility. Pasternak was the attorney who sought discharge of the bankruptcy. I can't see how it is that a malpracticing lawyer who's going to say to the client, by the way, hey, maybe you should list this. As far as the plan funding, the plan of reorganization, plain language of the plan states expressly that rights for fraud and malpractice claims against the debtor's professionals, i.e. Pasternak, are preserved. Moreover, Lightstone Group had in 2013 an endowment of some $500 million, excuse me. When I deposed Spry in the related bankruptcy of the successor corporation, he told me that he had maybe $100,000 of his own money invested into what should have been $14 million. This is what caused the Del Bello firm to then turn around and not receive the $1.1 million in creditor funds that it should have received and allow its escrow account be overdrawn some $800,000. Thank you.
Thank you very much. LaSala versus Russell?
May it please the court, Claiborne Henry on behalf of the appellants. This court should reverse because the affidavit submitted by plaintiff's expert in opposition to our motion for summary judgment failed to address several key assertions that lay at the root of understanding the treatment, lay at the root of understanding why Mr. Montilla, the decedent, received the treatment that he did. As a result, plaintiff's expert affidavit cannot create a tribal issue of fact on this record. The first point on this matter is that our expert explained that the peak brain swelling period for someone who suffers a brain injury is 36 to 72 hours. And he explained that in this case, the decedent had reached that peak brain swelling period, that his target sodium level had surpassed the elevated range that they were looking to get him at, and that at that point, they appropriately began weaning him off hypertonic saline, letting his body return to the normal range.
The allegation. I understand that they didn't counter the 72 hours, but I'm not sure that they needed to counter the 72 hours. What about their response that defendant's response to the sodium level in the early morning of October 23rd was too little, too late, that when the amount started going up, it was not adequately addressed, as a result of which the sodium continued to drop, and that was the cause of the brain damage to the decedent?
Yes, Your Honor. Well, I think on that point, plaintiff's expert fails to address the lag time between the therapeutic effects of hypertonic saline and the sodium level of a brain injury patient. And this is something that is established in the medical record. So, for instance, when Mr. Montilla arrived at the hospital,
You're saying, though, after 72 hours, you're out of the ballpark, and there's no reason to even check the sodium levels anymore? Everything's good?
No, Your Honor, I'm not saying that at all. When I'm talking about specifically, their claim here is that once they saw his sodium level at 136, which was 1 point below the normal range, they didn't act aggressively enough when they increased it from 18 milliliters to 25 milliliters per hour. Despite it being a 50% increase, he's saying there's too little, too late. It should have been a more aggressive increase. And our response is, and this is what the medical records show, is that there's a lag time between the therapeutic effects of hypertonic saline and a patient's sodium level. So when they increased his saline infusions by 50% and his sodium level
What
didn't...
they're arguing is that it never should have gotten as low as it did, that was the error, that the sodium level never should have dropped to that point, and it was only because it was allowed to drop so low that they couldn't bring it up quickly enough.
And again, that's...
They're not saying that it turns on a dime. They're saying that it never should have got so low in the first place, and then there wouldn't have been that problem.
Yes, Your Honor, but the sodium level didn't get that low, right? The normal range...
But he opined that it got lower than it should have gotten, which is what caused the problem. Why isn't that enough to create an issue of fact?
Because the sodium level is 137 to 147. He was within that range the entire time. When he dropped to 136, which was 1 point below the normal level, his doctors immediately recognized this very, very mild form of hyponatremia, which is low sodium in the blood, and they increased his saline infusions.
Are there any other questions? Okay, thank you very much.
Thank you, Your Honor.
The next case is Karen DeSecchi versus City of New York.
May it please the court, Ephraim Wertenthal for the appellant. In this case, the stairway and landing leading to the construction trailer of plaintiff's employer Phase 1 clearly was either a passageway, a walkway, or a platform. It clearly fits in within one of the enumerated instances of the Industrial Code 23-1.7 sub G. This court has repeatedly held, and other courts have held, that a stairway is a passageway. We've cited at least a half a dozen cases, Conklin, O'Brien, Wayland, Ziegelbond, Smith versus McClure, where this court and other courts have held that a stairway is a passageway within the meaning of the Industrial Code so as to invoke Section 241 sub 6. In fact, one of the cases of this court right on point is Conklin versus Port Authority. That is a case where they had a chicken ladder, which is, an impromptu sort of a stairway going to the construction trailer or the shanty, which was covered with mud. And this court held that that constituted a passageway. There's no reason why, in this case, it should be any different, that the stairway with the platform leading to the door where the plaintiff fell on the ice is a passageway. And if it's not a passageway, and we say it is a passageway, then it certainly is a walkway. In the case of Quigley, which is another case of this court, Quigley versus the Port Authority, over there, it was an open area right in front of the plaintiff's employer's construction trailer or shanty, and he slips in this open area. The court said, well, it might not have been a passageway, there was no stairway, but it was a walkway. So in this case, it's a defined, discrete area. It's either a walkway or a passageway. It certainly fits within the parameters of 1.7D. The respondents make much ado in their papers about this not being a construction area and that the plaintiff not being involved in construction activity. First of all, the motion court agreed with us that at the very least this is a question of fact, whether he was engaged in construction activity at the time, but it's clear that under Pratt's versus Port Authority, that this work that he was doing was ancillary. He was going to his construction trailer, as he did every morning, to prepare for the day's work, to look over construction plans, to conduct meeting with employees, and it's a place where they kept equipment and construction plans, and he went there multiple times during the day. It was within the construction site. The construction site was surrounded by a fence, and this was 150 feet from the main gate inside the construction site. There's no question that this was an integral part of the construction site. So we have here all the elements that are required for 241 sub 6. It's a passageway, it's a walkway, we're on a construction site, and it has ice on it. It's a classical 241-6, it's a classical case of a 23-1.7D under the Industrial Code. Unless there are any questions, I'll rest my brief.
Thank you.
Your Honors, may it please the Court, my name is Eric Berger. I represent all of the defendants in this case, and we respectfully agree with Justice Sherman's opinion. We think he got it right.
Counsel, how can it not be a passageway when it was clearly a stairway leading to part of the construction work?
Your Honor, he was injured on a platform. So there were two steps to get to the platform. He wasn't on a stairway. He was trying to unlock his front door.
Wasn't that part of the stairway, though?
I don't think of a platform as part of a stairway.
Well, then if it was a platform, isn't that another component of 241-6?
Yeah, the cases define a platform as a surface where you're working on. So the main case, the appellant
Why wasn't
cites.
he working there? He was going to have a meeting to meet with the plumbers in the morning to talk about what work was to be performed that day. Why isn't that where he was working?
That's not construction work.
Why not?
Meeting and talking is not excavation, it's not demolition, it's not putting a hammer into nails. He's going to his office in the morning.
Your only argument, because there's three different surfaces we're talking about, is your only argument why it doesn't fit into the platform category because he wasn't doing construction work? Is that the sole argument?
I think that's the main argument,
Otherwise,
yes.
you concede that it was a platform, and as opposed to a passageway or walkway. It was a platform, but it wasn't construction work?
I don't think going into an office,
No, I understand. I just want to make sure I have clarity on this
Right.
issue, that you're not disputing that the platform category would apply, but for your argument, which applies to all three categories, that he wasn't doing construction work at the time. Is that correct?
I guess that's correct, yes.
Okay.
So the argument in response to ancillary, well, all the cases cited by the appellant, ancillary, the worker was doing something. The plaintiff was actually doing something, whether it's carrying coffee, whether it's going to get materials, whether it's returning from having gotten materials, whether it's carrying something, whether it's going to carrying something. They're all distinguishable from the case here because the plaintiff wasn't doing anything. He was on his way to work.
Back one moment to my other question.
Right.
You said you're conceding it's a platform, but for you don't believe he was doing construction work. Are you making the same concession with respect to the passageway and walkway arguments, or no?
I mean, all the arguments are essentially related, such that I believe that the way Justice Sherman reached his decision, which is really unclear the way it was written, was that he wasn't doing construction work at the time of the accident.
That's your argument with respect to all three categories.
And that the trailer itself is remote from where the actual construction work was being done. That's essentially the basis of the argument, yes.
That's your argument. Okay.
The courts have repeatedly held that he doesn't have to be doing something at the time. It just has to be part of the work that he's doing. The case of Quigley versus Port Authority, Conklin versus Triborough Ridge, O'Brien versus Port Authority, in all those cases, all the plaintiff was doing was going into the construction shanty. He wasn't banging anything into a wall, he wasn't doing anything. He was walking into the construction trailer of his employer. In all those cases, the court held that those were either walkways or passageways. They were ancillary to the work, and therefore they were considered part of the construction activity, which is protected by 241 sub 6. Also, just with respect to the argument that a landing is not a part of the stairway, this court has repeatedly held that a landing is part of the stairway in Smith versus McClure. It's a First Department case from 2005, where it said that where he tripped over tools on the landing in the stairway, court said it was a passageway and therefore was subject to the protections of 241 sub 6. So, you know, the stairway, the landing, it's all part of the stairway. And if you'll argue that it's not a part of the stairway, we vigorously say it is part of the stairway, it's a platform and it's a walkway. Under either one, it's a labor law case.
Thank you very much.
Thank you.
People versus Niles.
Good afternoon, Your Honors. May I briefly wipe down the podium?
I'm sorry, what'd you say?
May I just
Oh, sure.
briefly? Thank you. Good afternoon. Hunter Haney for Appellant Paul Niles. This appeal presents a true test of the boundaries of judicial tolerance for coercive police interrogation tactics. Here, detectives deployed a series of deceptive strategies to extract the confession of Mr. Niles.
Isn't that allowed?
I'm sorry?
Isn't that allowed under us, on current state of the law?
Police are not allowed to unduly pressure and extract
But
an
aren't they
involuntary.
allowed to make misstatements about the evidence?
They are allowed, correct. But to the extent that they did here, they're absolutely not allowed.
It's not,
Here in this context.
your objection is not that they made statements that were untrue, that your argument is that it's coercive?
Exactly, under the totality of circumstances that this court is required to assess in looking at the voluntariness of a statement, the court has to not only look at the coercive police tactics, but the context of the broader interrogation. Here you have a defendant who was homeless, suicidal, and physically and mentally exhausted. The prosecution failed to show that the resulting statements given over 6 hours and 19,
Sir,
yes,
I'm sorry, doesn't the record show that of the 6 hours, quantitatively, your client was questioned for about two hours and change, and of course during that period overall, he was afforded opportunities to have food and drink, have breaks. Is that correct, sir?
So it is correct that he was offered food and water.
And is it also true that he was not handcuffed? True?
He was not handcuffed.
And is it also true that they didn't flash any weapons?
Nor is that required to
And,
find
and it's also true that they didn't
involved.
threaten him in any way? Or they basically repeated, sort of cajoled him to be honest, that he was being dishonest?
They did engage in a variety of coercive interrogation tactics that are well known for extracting false confessions.
And doesn't the record show that he had an opportunity to actually sleep during the 6 hours in the room?
To actually what?
Sleep, like he took little naps.
So even accepting that he was actually sleeping, which is not in the record, prolonged isolation is actually the problem here. That's one of the many coercive tactics that the detectives use, as the science in our brief has shown. It's because it heightens distress and encourages one to remove oneself from the situation by making a statement. So when you consider that, the fact that he was left alone for some period of time, and on top of that, the 19 invocations of his rights throughout the interrogation, 19 invocations of his right to remain silent, and then 2 invocations of his right to seek counsel, which is especially probative in this state, a state that values the right to counsel over pretty much all of the other rights that defendants have. That's an extremely critical part of this analysis.
Well, counsel, I mean, certainly they violated the rights by continuing to question him, but can't the statements be used for impeachment?
No, absolutely not. They were involuntary because, again, under
How was it involuntary? My colleague just went through a whole litany. He was offered food, he was offered drink, the bathroom, even, do you want to call someone? He said he wanted to call his mother. There was a video where he indicated, police were nice to me. They didn't do anything wrong, no force, no handcuffs. So how, all that we've said is still involuntary.
So can I take each of those piece by piece, if it's possible? As for the food and water, they did offer him food and water, but it was well after he made the inculpatory statement at the 3-hour mark. And in response, Mr. Niles stated that he wanted to kill himself. And that's hardly a signal that the police should be continuing with this interrogation. Also, an offer of food and water is virtually pro forma in interrogations of this nature. And it just is, again, really ticking a box. And when you look at the broader context of this interrogation, you see, if the court reviews the video, you see his palpable, dire exhaustion.
Time for rebuttal to amplify that.
Thank you.
May it please the court, I represent the respondent on this appeal. As the court has observed, there are a number of factors supporting the voluntariness of the defendant's statements. The defendant was offered food, drink, and the use of the restroom. Weapons weren't drawn, he wasn't handcuffed, he wasn't threatened, he wasn't physically harmed. And I think most telling, more so than anything I can tell you here, is I implore you to watch the videotape itself if you haven't already done so, because it seems to me that the affect of the detectives was perfectly respectable, cordial, I think even solicitous at times, and I think it totally belies the notion that there was any coercion. As was pointed out, even the defendant himself acknowledged that he was being well treated. Again, Detective Ulan arranged for the defendant to speak to his mother, so the notion that he was isolated from his family is not supported by the record. Again, and he was sleeping. If you watch the videotape, you can hear the sound of heavy breathing. So the notion is he wasn't isolated with his interrogators. It was a total of 2.5 hours over a period of 6 hours, which is really a relatively short period of time. I mean, I think I cited a case in my brief where 18 hours of interrogation is found to be coercive. This is nothing like this. And most importantly, the defendant never really confessed to anything. Initially, he denied any involvement, and he said, I bought the credit card from some crackhead. Then he said, okay, yes, I did rob her, but he steadfastly and repeatedly denied raping her. And even at the end of the interview, he reverted to his original claim that he bought the credit card from some crackhead. So the notion that he felt free to protest his innocence, in my mind, certainly belies the notion that he was coerced to say anything.
Counsel, can you address the ineffective assistance claim?
Yes, I can. I mean, my first argument is that it's not reviewable because I think a number of the claims involve questions of strategy. But I'll just quickly run through the alleged ineffective assistance. The first is the failure to request a cross-racial identification charge. And counsel's argument is premised on the Boone case, which wasn't decided until 2017, and therefore counsel cannot be faulted for not anticipating a change in the law. There was another one, the failure to object to the criminalist testimony. Again, her testimony is completely consistent with John, didn't violate the Confrontation Clause. The criminalist said that she independently analyzed the data and the results obtained by the individual analysts who did the individual tests, and she reached her own independent conclusion. So therefore, there's no Confrontation Clause issue there. And as far as the failure to give an adequate summation, this was an overwhelming case of guilt. You had not only the defendant's vivid description, you had her line of identification, you had the defendant caught on surveillance tape within an hour of the attack using her credit card, her bright blue Chase credit card in 2 different locations. And most importantly, you have the DNA evidence. And as the criminalist pointed out, there was only 1 in a trillion chance that someone else shared that DNA profile. So in the face of that, the defense attorney was certainly hard-pressed to say anything that could have swayed the jury. So I think it's a question of more the strength of the evidence than any deficiencies on the part of the defense. And unless the court has any other questions, I'll rest on my brief.
Thank you very much.
Thank you, Your Honor. It's just 3 quick points on the voluntariness argument, just to pick up on where we left off. Regarding the access to family, or the purported access to family, at one point he was able to speak to his family during the 6-hour-long interrogation. But more crucially, his family was actually weaponized against him to obey his will numerous times, with detectives conveying, just minutes actually before his confession, that they had spoken to his family. And that exacerbated his sense of isolation and the sense that resistance was futile. At other points in the interrogation also, Mr. Niles conveyed how isolated he felt and how he felt his family had abandoned him. So I think my adversary is overstating, again, the import of access to family when one looks at the totality of the circumstances in this case. As for the suggestion that the detectives were polite to him, my client did at one point acknowledge, in response to a leading question by the detective, that they were treating him well. But these statements, again, occurred precisely in the middle of a sequence of other coercive tactics, questions which were extremely problematic, and leaving Mr. Niles just seconds later begging detectives to stop, saying he couldn't take any more of what they were doing. And finally, regarding the significance of the denials, at certain points, Mr. Niles did deny raping the complainant, but the allegations in this case did involve theft of certain items from the complainant during the course of a rape. Given that he admitted the theft, he was already placed at the scene, and the denials of the rape had little effect. And adopting a rule here in this context that any resistance, as my adversary suggests, on defendant's part just ends the voluntariness inquiry would basically write this area of the law out of existence, if you think about it, because the prosecution will always be able to come up with some citation of resistance over a prolonged interrogation as occurred here, again over 19 invocations of my client's right to remain silent and 2 invocations of his right to counsel. So we would ask the court to reverse and order a new trial. Thank you.
Lobby, be advised, court is over. You have two coming out.